94.7 Asempa FM, Sunny all talk all day. Ekosiisen Jumedian Wasuguswa, Uti, and Mayana Masama train, Mayako Abba. Meaning your Sabon Sufremi will be in studio, lawyer Eduji Tamaklo, a member of the NDC legal team. And Eduji, now we're counsel to one of the parties in this suit.
No, a different one.
Oh, I know a different one.
Yeah.
Okay. And lawyer Andy Apia Kubi, or no, your MP. Asante Achem North constituency, former deputy railways minister. Wabekansa ewo studio ha. And maybe I'll start with you, Eduji. Now, yashe enra ruling Supreme Court eba, you know. You obviously disagree with the ruling, I suppose. Reasons
Yo, Obi. So once again, yechia etiefu nyina. Enra na eyaye arewo sempa. In fact, na me wo court na judge ruling no by.
Okay.
For some strange reason, it's like I was expecting it, but maybe not in the form in which it came. Now, my expectation in it, and maybe with my experience with the court. So usually when matters of this nature come, they'll prefer some make consolidate the substantive matter and the interlocutory applications, normal deciding. And the reasoning has always been said, you do not want a situation where you give an injunctive relief, a big give you an indication, say you are basically prejudge the outcome of the case. And so, oftentimes by reason of caution, and a desire to maintain the status quo, it's okay. Instead of giving a ruling, submit a memorandum of understanding or a memorandum of issues. Now, with the memorandum of issues, then we'll do a formal hearing so that my decision now it settles everything.
Okay.
Very real circumstances now who say those interlocutory matters are determined ahead. Now, in this particular case, like I pointed out, Obi, the challenge will right from the beginning, and then they say, Emrana petition here finally the High Court in Cape Coast.
Yes.
We were handling it.
Yes. Okay, I remember.
Yes, we were handling it. Until finally answer ye bibiano. Okay, there was an application to injuncting prior to the election of the speaker.
Yes.
Good. Until ye call for the injunction hearing, in the raise more or less like an objection. In the extent say, you see, at the core, in fact, relief one of the petition, is basically seeking an enforcement of Article 94 to A.
Yes.
In the year, catch the High Court judge and they said, look, my lord, that particular constitutional provision, it has not received any pronouncement from our apex court.
Okay. In terms of interpretation of the scope?
Yes, the scope. In fact, the only time that provision about close to a judicial pronouncement in terms of its scope, a year, the case of Bilson and Rollins. Okaya, October 1992,
Ekosiisen
NDC filed Rollins the nomination as the presidential candidate. Then, now late, lawyer B. Menu as lawyer for Bilson. He issued rates at the High Court. Justice Esrifi Bonzi.
Okay.
And Anna or your judge, was our case. At that time, now, NDC are filing Rollins in nomination papers in Adida. And no call say, Tio, the presidential election law, that PNDC law, that time near 1992 constitution. So we're using the PNDC law then. But the provision is in pari material with the AOCC. It's basically been lifted into. You know what can I say? The constitutional provision, and they say, you should not owe allegiance to a country other than Ghana. But a notorious fact say Rollins ne papa in Ghana ni. Ne mami ne Ghana ni. So by reason of that, no a dual national. Intino nomination at NDC a file amano no offense that particular law. To that extent, the nomination and everything ought to be what set aside. and he injuncted. So there was an application for injunction to restrain Rawlings
from filing
the nomination to contest the election itself. And omu raise these issues. And a judge no can say the said provision relates to allegiance to a country other than Ghana. Yes. So Bilson can say what he expects Rawlings to attach to his nomination for is a certificate of renunciation from the British High Commission to show that he no longer owes allegiance to.
Did he ever, or had he ever, at any point in time, owed allegiance to Britain?
No, Senior, I'm just talking about.
The fact of the case.
Yes,
Rawlings.
Yeah. So his point was that to the extent he said Rawlings, ne papa, a year Scottish or what? Yes. United Kingdom. That's what they use. Yeah. He needed to have gone to the British High Commission here in Accra and obtain a certificate of renunciation in order to permit him to contest the 1992 election.
But the position I'm putting now is that did he, Rawlings, at any time hold the British nationality?
So I'm drawing the distinction because
if he didn't, then renunciation wouldn't come in.
No, hold on. There are two things. You see, people are confusing citizenship
with
allegiance. To allegiance. So we need to draw that distinction. Into only taking the view said the mere fact that your father is British, you owe allegiance to Britain.
Okay.
And so to that extent, you needed a certificate of renunciation to demonstrate. Yeah. So he applied for an injunction. And the court ruled on that injunction application. And the view the court expressed was this, that there are two modes of renunciation, actual and constructive. Constructive in the sense that while conduct can show say you do not intend to owe allegiance to a country
to any other apart from Ghana.
Exactly. And so the long service of Jerry Rawlings in the military, having taken the oath of allegiance, and also the fact that he was also head of state for many years and having taken the oath of allegiance constructively, he had demonstrated that he owes allegiance to Ghana and only Ghana.
Yeah.
And so he need not go to the British High Commission for a certificate of renunciation. Yeah. And two, even in filing his nomination, he also had what you call the statutory declaration. In that too, he declared that he owes allegiance to only Ghana. So when you put all of those facts together, what you discern is that he owes allegiance to only Ghana and only Ghana. Okay. And that is how the injunction was refused. Okay. And Rawlings then permitted to contest. So we then indicated to the judge in Cape Coast
High Court
that this had been the law relative to these matters. And so we beg you, even the injunction hearing, stay proceedings, because over Article 132 in the course of any proceedings, in the Constitution, Article 132 or say, in the course of any proceedings, if an issue of interpretation arises in mandatory terms, or say, you shall stay and refer. So we said that provision is in mandatory terms. It does not admit of discretion.
Yeah.
So now that we are saying this, another person is also saying this, please stay proceedings, refer, so that whatever the Supreme Court will say will bind all of us. Again, my learned senior, Frank Davis, who was opposed and says, obviously they had anchored their case on Senator.
Yeah.
And indicated said the Senator decision is clear. And so 94 does not require any further interpretation. So the judge can proceed. The judge agreed and then proceeded.
And not the ruling
by the first injunction prior to the election of speaker.
Yes.
In the court substantive matter. Until when it got to the FNO setting down the issues, in the SR raising the same constitutional issues, he should raise that issue and address it. And also be an issue. And on our Kaya, Amalbani no issue, Amalba withdrew from the case. Exactly. Hold on, Justin, it's a key over. Now, even in that, again, it was opposed that there is no basis for the referral. You can proceed. And that was when he gave the July judgment. Yeah. Now, the point we had raised was that Zenato only construed 94
1A.
1A.
Yeah.
And 94 1A deals with a citizen of Ghana, the
Has
age of
attained the age of
21,
21.
and is a registered voter.
Qualification of
Three.
a citizen.
Yes.
3.
Yes. Yes.
And has nothing to do with owing allegiance
Allegiance.
to a country
Yeah.
other than Ghana.
Yeah.
So 94 2A had never received judicial pronouncement
Ekosiisen
alleged by
on
the Apex
Asempa
Court.
FM.
So he should stay proceeding. So the judge in his judgment, I can say, what kind Zenato, and what kind of contentions are there to and in his
They were
mind,
different.
And in his mind is the same.
Okay.
It's the same. And so there was no need for an interpretation.
Okay.
And proceeded to then apply the Zenato timeline. Because, when I argue Zenato, the point was that at that time they were seeking to enforce the NDC constitution. And I say, there are two modes of becoming MP in this country: independent candidates and through a political
On the
party.
ticket of a party.
It is who begin to apply the constitutional provision at party primaries. You create a disadvantage for persons who go through the political party route.
Yes.
Because the independent candidate, the obetran is obetran till EC, be open nomination, no
Not
file. But once I go through the party issue and you begin to apply 94 to me, it means I should be qualified even at party
At
stage.
the party primary stage.
At the party primary. So I gave the scenario of the constitutional provision at ECA say I need to be 21 to
Ekosiisen
become
on Asempa FM.
parliamentary candidate.
candidate.
Meanwhile, per my birthday calculation, I'll be 21 in September. Party primaries in no August.
Yes.
Technically, July, August. Technically, it means even though I'll be 21 before the polls, by party rules, I cannot.
Yes.
To create a uniform, we need to start the computation from the day nominations are open.
Okay.
And the court agreed.
From the day's nomination
For the general election.
Okay,
Not party primary. Because they were seeking to apply party primaries.
Okay.
And that time it was the question of registered voters. And so there's going to be a limited registration exercise.
Into obey me
before the election itself. So don't hold it against her now.
her.
And the Supreme Court agreed. So when this particular matter came, we suggested to the court that, look, if you look at the electoral laws of this country, especially parliamentary issue, the principal law governing it, except the 1992 Constitution, is the Representation of the People's Act, PNDC Law 228.
You cannot sidestep the Constitution.
No,
apart from the Constitution.
I know the primary law, but there's a law that governs parliamentary primaries in this country, which is the Representation of the People's Law, PNDC Law 284.
And that one in itself is
A reproduction.
consistent with the
Constitution, absolutely.
Exactly.
And indeed, technically a reproduction of the various
Exactly.
provisions.
Because the provisions are in pari materia with this.
With the
And just that it has more expansive rules on parliamentary election. So we then suggested to the court that, with the greatest respect, if you apply Zenato
Yes.
in the manner in which you want to apply, you do grave injustice. Because, one, Zenato didn't explain the scope of 94 2A.
That's true.
It did a different constitutional provision.
Yeah.
So if you apply it wholesale to the facts distinguishable, you will create injustice. The judge disagreed with us and applied Zenato
For 94
2A
in the High Court.
in the High Court. In the High Court. And that is why I am saying, we need to have a more broader conversation about this matter.
Yeah, but the Supreme Court is leading the way.
No, so so when that matter came and we explained these differences to the court, obviously he disagreed and proceeded to give the judgment. Then we pointed out, look, Okaya Indum,
Yes.
2016.
On a Charlotte
Osei issue. No. He went to the court and said he ought to have been given all the Ateron party rule before the disqualification.
Yes.
The court agreed and said what Charlotte Osei did was improper and set aside the
against the rules of natural justice.
Fantastic.
Yes.
The Electoral Commission, dissatisfied with the High Court matter, invoked the supervisory jurisdiction of the Supreme Court, getting closer to the election. The Supreme Court, speaking to Her Ladyship Sophia Adingra, I can say, nomination period is not an event. It's a process.
A process.
And that process only terminates at the point where the Electoral Commission had given the party involved the opportunity for amendment, corrections, and all of those things. So the mere fact say nomination period, per the notice of poll, because from January 3rd to January 4th, it does not end there. It ends at the very time when EC has scrutinized, called you to come and do your corrections and others.
Okay.
So our contention was that in the case of Ekosiisen, Emra Obeye candidate or filing a nomination, the concerned citizens of Assinov, a petition the command district electoral commission officer Assinov.
Emma or referred about national.
And no case they are waiting matters. On no need to by stroke of a pen, no one case will be a disqualified. Into the by regional office. Now my maybe nana or your regional director, central region EC.
Okay.
You know, no so can say in same way there. Emodu. Into another the bank crime. In crime for who you know, and I'm afraid Ekosiisen. Said this is the petition that we have received from the concerned citizens of Assinov. What says that? What I say? Na okofa ne certificate of renunciation
at
the buy
at the time now.
Yes, na ba. In okofa bre electoral commission. Into electoral commission everything ye bibia we no say. Now we are satisfied. Go ahead and contest. Obi, that is what happened. So we then now told the High Court judge that these are the facts. Completely different scenario.
At the time he was making his declaration on the nomination form.
Yes.
And you know the value of that declaration.
Fantastic.
At the time when that OS had declaration, signing on to Ekosiisen may qualify to contest. At that time, now.
The renunciation certificate.
Yes. At the time, not renunciation certificate, no, my.
Okay, so let me explain something to you.
Okay.
No, this is a very simple question.
No. So I'm explaining. No, don't worry, senior. Don't worry. Relax, relax.
Yes.
At the time of New Year statutory declaration,
Yes.
what was in the declaration?
I, Ekosiisen, I confirm that may qualify to contest.
And so I owe allegiance to no other country.
Absolutely.
And yes, sir.
Absolutely.
Good. And Maka say, allegiance is not coterminous with citizenship.
Obiajitum.
So just
Obiajitum.
And so, when I say I owe you not allegiance, allegiance is not forced. Allegiance is voluntary.
Voluntary, yes.
So if I write to you in 2019, say, and let me explain this quickly so I come here. Embra obeye parliamentary candidate Emma NDC no. Obeye parliamentary candidate Emma NDC no. Oh no, senior, don't worry. There are factual matters that I want. You are not aware of certain things. Inti Emra obeye parliamentary candidate for NDC no.
Yes.
Na oye attestation with his constituency chairman. Stating the fact that he had now become the NDC parliamentary candidate. Na use that as the grounds for the renunciation to the Canadians. That is what was stated in the application to the Canadians. So having become the NDC parliamentary candidate, on these grounds, I do not want to have anything to do with Canada. So at the time when he entered the Electoral Commission, for all intent and purpose, he had disavowed every allegiance to Canada.
Even though not certificate,
no.
But now we're making
making applications and everything there with an attestation from the constituency chairman attached. No doubt. And that is why I am saying, sir, you need to appreciate what exactly happened in the Assinov matter properly. Because, you see, when you look at it...
All these were in evidence.
Which one?
No, and a high court.
And I make us say, high court no take the view say these matters have been resolved by reason of the Senator decision. And Mama we who has said, as far as the Senator is concerned, the Senator never construed the scope of 94 to A, and that is world accepted way. Until the year can say, what you section 20 of the Representation of the People's Law now,
Yeah.
PNDC Law 284.
Yes.
21D, I can say, basis on which you can cancel a parliamentary election.
Yes.
It provided about, almost 5 ground. Ground D. Or say it should be established. Say, at the time of your election, you were not disqualified.
At the time of your
election.
And what's the scope of that statement? At the time of your election, you're here for.
When is your election? And here December 7th.
Is it settled law?
No, but that is December 7th. When is your election to become an MP?
And some have said the election there, no, a process. It begins from the nomination.
That's even a legal stretch.
Anyway.
That's even a legal stretch. So basically what happened is say it was on this basis.
Okay.
In the air can say the law that specifically deals with parliamentary election, law 284.
Yes.
And 21D no can say the time I will begin to question the person whether he's qualified or disqualified is at the time of his election. And the time of the election of Ekosiisen was the 7th December.
Okay.
The certificate of renunciation, for the sake of argument, came on 26 November.
Okay.
So how do you go about?
Okay.
You understand?
On the initial way now we're raising us. I mean, honorable, and then we'll come to the Supreme Court.
All the laws. We started by saying that
Yes.
the Constitution is the primary law
Of the
governing
land.
these elections.
Yes.
I want us to talk about elections. The Constitution expects a pre-qualification for every candidate to start the process. All those laws in reference, they are subservient to this Constitution. So, any of the provisions in all the laws, whichever you take, if it does not submit to this Constitution, it is inapplicable.
Yes.
And you go to
Honorable Katrina.
of course you say we laws no. Of course says laws no.
Yes.
994 no. And they dealing with
Eligibility and qualification.
to participate.
Yes.
Ekosiisen on
Indeed,
Asempa FM.
in the particular case of Zenato, it was not about the association with another country.
Yes.
And then the allegiance to another
Yes.
country. It was about
So, are you registered voter?
were you ready, qualified because of his age, her age, and her
More of registered voter.
now, say it was about the age, Ninti na onye registered voter no.
Oh,
Now we're qualified.
Nato was almost 40.
At the time, the
It's
now
18 years. It's 18
on the
years.
who's that 94-1A, a can
Yes.
citizen of Ghana,
Yes.
attained the age of
21
21,
years.
Yes.
and a registered voter.
Yes.
But on the it was more on the registered voter.
Now
Wabro
more than 21.
Absolutely.
But now on your registered voter.
A honor issue.
And in the qualification, no, it was 94-1.
1A, yes.
1A.
Yes.
94-2. 94-2. And in this particular case of question,
Question, yeah.
94-2. And the
Yes.
and you see all allegiance to a country
Other than
and
Ghana.
other than Ghana.
Yeah.
A honor council person should say we are citizens now. It
Ekosiisen
doesn't
on
mean that you
Asempa
owe
FM.
allegiance to the country. But what he refuses to understand is that before you can become a citizen, you must swear an oath of allegiance
That's
to the
true.
country.
Absolutely.
That's true.
And son obey
A citizen.
So when you have sworn the oath of allegiance to pre-qualify you to become a citizen, how would you come out and say citizenship is not
Coterminous with the
coterminous
allegiance.
with allegiance? How do you justify that? And it once you swear an oath of allegiance to pre-qualify you to become a citizen, the allegiance is presumed in that declaration.
Is that presumption not rebuttable?
Rebuttable, of course.
It's not
So
because
I've written to you disavowing
no.
the allegiance.
Listen.
But no, some presumption they are rebuttable, at least.
No, you have pre-qualified
Okay.
upon your allegiance. So when you allegiance to the country now, you don't qualify for the certificate.
For the citizenship.
Now when your citizenship, you now flag a citizenship. We say, "Adia ma minya citizenship."
Mempebio.
Can you force me? Listen, adia ma minya citizenship, and you hold the citizenship. How can you?
He was no longer holding on to the citizenship.
Was he not a Canadian?
No, by 2019.
Citizenship.
Okay. Sir, renunciation certificate. Okay.
I didn't engage.
Sir, renunciation certificate. You are still a citizen. That's your argument.
A application to become a citizen.
Yes.
You didn't just put your application there and became. No.
True.
You went through a process.
Yes.
The process the end, and the man also oath, in the oath, and I will pledge your allegiance to the country.
Yes.
And yes, sir, we be a Canadian citizen, and that will tender in your application. No.
We go through process.
Go through process, and it ends there. Now, what's oath, what pledge your allegiance when your citizenship, we say you start from the end of that process, and you come down up to the point your Bema certificate say, and then what do you know? And now you Canadian citizen. I fail now because say you don't have any allegiance to any country. But time no, what pledge your allegiance now? That's crap paper no. A chance we are citizen in the allegiance is subsumed in your citizenship. It is not until you are discharged completely and fully. And it is the question to ask simple questions. Time no or your declaration say me owe allegiance to any other country. So time no.
A nomination form.
Nomination form. And indeed, it is the beginning of this process also. Electoral process. That is the beginning. Time no, we declaration. I was saying, now in that declarations all signed before a commissioner of oath.
Yeah,
and it is an oath in itself. It is that time now. Yes, I did. Now we are citizens, and I said now we are citizens.
Now the documentary.
Emaya, a chance renunciation, and you're complete. And at that point, now we are citizens of Canada. And indeed, say can see for citizens of Canada. At that point, they say we are citizens. No, how can you say we are citizens, but mini allegiance?
But say my application, no. My application to renounce my allegiance, and by extension to renounce my citizenship.
And until I make will say, we application for citizenship. In itself, it is not enough to confer citizenship on you.
You need to get the certificate.
You need to get the certificate.
Now you are a citizen of Canada.
Citizen. The same way, we say at the end of the day, mimpebio, and so at the end of the crowd. And say at the end of free will, sir. Amma when you record to prove, say at the end of the bio. But as long as we do say we are citizen in there, now what we can say, I denounce my allegiance. The mom, we are citizen. At the end of we are citizen. You can't take it away and hold the certificate that is evidence of that allegiance.
But don't we also interpret it and say, listen, assume a bibia so person or ye Ghana ni complete. We're making the first move. In an intention ye clear. Say or person on Canada for a tin time. Say onya making application. Going through the process, I ability to getting a certificate, as a Canada phone,
very well.
On one to mean control.
Very well. The same way.
Okay.
And the application could to Canadian embassy say, 7% be a Canadian. Does it confer citizenship on me?
No.
So the same way, declare intention,
certificate,
Maya, you have not denounced. And that is a simple, interpretation of the Constitution, because allegiance in the citizenship. And to say, by word of mouth, we see what denounce so. Nasa oda sukra, the symbol of citizenship and allegiance in the Maya citizen. Better yet to dissociate allegiance from citizenship. It's not possible. And the question is simple to ask. At the point where your declaration, you say, Many citizen, was he or was he not? And he said, was he no chese? Unya renunciation wa ebeje Canada near many few in you are still. And at the point no declaration, you can see a list of Canadians in Nidi home. And at the point no with the application call Canada say person citizen, you can see him for citizens of Canada within him. And vain attempt say you bet me dissociate allegiance from citizenship. It is not possible.
In your case, no, you agree with the High Court in Cape Coast's decision.
Yes.
Say based on that,
Yes.
now on eligible to contest the parliamentary elections.
And now we have the test of 94 to a person shall not be qualified. So the emphasis is on qualification.
Yes.
Now qualification is saying if you owe allegiance.
Yes. To a country
to a country. And at that point, now owe allegiance to that country by way of the citizenship are proven. No, he was not qualified at that point.
Senior, can I ask a question?
Go ahead.
Okay.
What is the timeline in Article 94.2a?
Article 94.2a in my timeline, yeah.
Exactly.
There is no timeline.
Exactly.
Listen, exactly. Article 94.2a.
So what is the timeline in Article 94.2a?
94.2a, no say. The timer will be participating.
Yes.
You must be qualified.
But I know you're in session.
No. You shall not be qualified. Yes. No. You shall not be qualified
to be a member of parliament.
To be a member of parliament. To be a member of parliament, you don't jump from your home to a parliament to become.
You go through a process.
You go through a process. And it's a process, no. Yeah, bonsoir. Wow, we are qualified now, Bobby. And it's a you see, who can become a member of parliament? You have to qualify to be considered, qualified to be participant. And you don't also jump to parliament. You need to go through a process. But before you start the process, you must show your qualification. Yes.
So, senior, from the eloquent submission you are making, okay, from the proposition you are making. Who say it's not an event?
Yes, it's not an event. It's a process.
Fantastic.
So
I filed nomination, right? Then within that process you call, the Electoral Commission calls me that I have received a petition about your qualification, that you are not qualified. And what fro? Say, bra, nabe explaining your qualification. And I'll start meeting your certificate of organization, man. In fact, all my work of foreign affairs.
Listen to me.
And I'll call you attestation.
Man, you this point.
No, all my work of foreign affairs call you attestation at the count home. You know the brom because the document coming outside. You know the count on the brom. You say yes. Based on this, go ahead and contest. Where does the process that you are alluding to?
Listen, media. I haven't
the
seen
process that you are alluding to. Where does it end?
I haven't seen.
If the process had terminated on the day the nomination closes, what would be the basis on which EC will be inviting you?
EC process, no. Yes. I will not go to it now, but what I will do is that at the time now, or sign a declaration, now or renunciation certificate, now.
That be that time no need.
Yes. So no we know. You see, qualify before you start.
But time easy to suffer no. Easy to suffer and the run in saka.
The easy to suffer no assign declaration.
No assign we that.
Listen. Wait a minute. You see, you shall not be qualified. At the time now we're starting.
Yes.
Now we're qualifying and now unqualified.
At the time of filling nomination
form. Because you made a declaration then. Yes. Say, I don't owe allegiance to any country. And it apart from Ghana. And it is that time, no. Did you owe or did you not? And he said, after you have made a declaration, say the next day, Kurano, unya certificate no. That is a declaration
null and void.
Because it was not the okay. And at that point, the onus is on you to prove your qualification. And it time now when you're qualified, easy call in the middle of the process. What be produce certificate be? The easy to fail to do, they say, why I reconcile the date of the renunciation certificate with the date of the declaration. One, Fancy say, what Timmy are convincing easy, say, we're discharging the proof. Obi Abeya allegation said, no. At that point, he had not qualified. Then the burden of proof shifts on that person.
Yes.
And nipa no obey no, or providing evidence to prove, say, time yes, a declaration no, a oath now swearing. Now we need certificate. Court to not take evidence. Or take evidence, come to a conclusion, say, yes, you were not qualified to become. So you had started before you became qualified. And therefore, by interpretation, your qualification is deemed to be before you start the process. And therefore, you have erred. But in any case, listen, in any case, I'll go through trial.
Yes.
Evidence will be now the court has spoken. Now constitution will say when you fail in the instant court, now we are unhappy. You go to court of appeal.
Yes.
And the constitution will say court of appeal the bad decision. Now, what I agree with him, say there might be a window. He said constitution didn't place any prohibition from further appeal, except that constitution can say appeal from high court, court of appeal,
yes,
without more,
yes,
and
that's where parliamentary
there could be an application for interpretation. Say, what does that mean?
Yes, at the Supreme Court.
Supreme Court. So when the law says that the appeal goes to court of appeal without more, does it mean, sir, it excludes the jurisdiction of the Supreme Court? Let the Supreme Court speak. Okay. But so far, Supreme Court in Kasa on that. But me, when me know, a brand no more training, you know, na me idea be say they should have gone for the interpretation of 1942 first, and could have solicited or asked for consequential orders. Naka adiaru create ya yanko started with high court or anyway because at the end the whole complaint was based on the interpretation of 1942.
No, but
it mean na me ya.
Yes.
Akabepe say meko
Supreme Court direct for interpretation of 1942. Now my Supreme Court pronouncement say when does it start? Now Supreme Court actually say ankasa time yi and the next say proof of renunciation. Unya sa ruling na.
Unya sa ruling na my case Supreme Court. Say ba say what can say there. Na say obi a wan ni sa de wo kenso no. Now otiatia constitution so. And to give us consequential orders. Obi a otiatia Supreme constitution so. Want to mean your MP.
Okay.
And therefore because want to mean your MP no. And election in the MP, you are nullify election. Now also you can't carry yourself as such. Now don't
and that
go,
was possible. No,
it's possible because say interpretative, declaration ba. Now what as a court to say? Someone can say dear. Now Mr. Court to say, Yanka said nipas Messi on your MP. Nipas Messi. Abana 2 year no netia constitution. You see, anything that is inconsistent with the Constitution is void.
It's void.
And the Supreme Court can say, because of the inconsistency in the process with the Constitution, and it is our process that we void.
But the lawyer on the opposing side, no bet me raise objection.
Yes,
that objection say an election petition was failed, and I was said that about
by all means, a lawyer no right to do that.
Yes,
but a right to do that no Also, so argument they say, we find this said court no my interpretive position no. Sa argument ni na be dissolve. Anything se court no ye decision on both arguments no. Na ye ko animu.
Okay.
Now I'm of the strong belief say Sekoban say omo for interpretation of 1942 no.
Yes.
And the other lawyer no raise objection. Court no be decision.
Okay.
And me very sure say court no be decision no.
Will favor
application.
Okay.
Court no we say pa. Na de o say court no be say.
Okay.
Enti Yakobani say ye. Na yakase ade no me ye ni nyina. Etia constitution. Supreme Court can say because of Article 1-2 no. Oh to me say a BBI edit constitution boy brano. A null and void.
Okay.
Make that pronouncement.
Okay.
The Supreme Court make his pronouncement say and I'm say one follow constitution in a year election it election we avoid. Supreme Court can say pair. No one say Supreme Court say so what can say a avoid there and they can say
assign off
MP no on to me MP na Supreme Court akwana ni mako kasa asem say isishaya na if 1 2 3 no ndi on to me MP there Supreme Court saka say ma on carry ni self say
oye
MP na yakoduru ho na say there ya number 1 number 2 number 3 number 4 there follow automatically.
Okay.
And inti untimi carry yourself as yes onya MP na to be na wa be carry yourself as MP. Enti edidi so. Enti me approach ya me prefer to say ankanya ni say court high court court of appeal anyway okay. And na council can be say
finally
somebody when he was out of time say Lord how innovative you can be. Okay, say no, be out of time. Process or the buy.
Yeah.
Trying to clothe himself with capacity to appear. Eti do baby and yet the normal process you can also follow another process a bit more, probably a better result, probably in terms of better time.
Yeah. I get you. Edwin, now me person me boost this question, sir.
Before I make a question,
yes.
So just 1 minute.
Okay.
We share sections 20 or PNDC law 285.
Okay.
I just want to
representation of
the people's law. Sections 20. Grounds for cancelling election results.
Okay.
Grounds
for cancelling
election
results. Okay.
Or say the election of a candidate shall be declared void on an election petition if the High Court is satisfied D that the candidate was at the time of his election a person not qualified. Or a person disqualified for election.
At the time of his election.
At the time of his election. Now, the same representation of the people's law, it draw a distinction between a candidate for an election to be an MP and a member of parliament. Which is section 9. Obi. And you see, these things never came in Senator.
Asempa FM.
Which is section 9 of the PNDC law now.
It's not a case to be considered.
And that is what the High Court judge did.
No. What I'm
See
saying
that with
is
the greatest respect, you should have the benefit of reading. But you let me just... Yes. And let me just read something. Qualifications and eligibility of members of parliament. 1, or say, a person shall not be qualified to be a candidate for the office of parliament unless in the provided grounds. Of the grounds he provided, owing allegiance to a country other than Ghana is not amount.
Okay.
Then when it came to 9.2, or say, a person shall not be qualified to be a member of parliament. First, or say a candidate.
Okay.
And if for the candidature, owing allegiance to a country other than Ghana is not there. So when it comes to 9.2, or say a person shall not be qualified to be a member of parliament if A, he owes allegiance to a country other than Ghana. So you will see that
and you become a member of parliament
only at your swearing in.
Only at your swearing
in.
And a candidate for the purposes of the election.
Absolutely.
You see,
Absolutely. That is why I'm saying, sir. That is why I'm saying, sir.
Article 94(2). It says a person.
A person, yes.
A person,
And
not a candidate.
Okay, and a person is a generic term.
And again, assuming so you are contesting, say 94 2 no.
Yes.
90
No, and we
PNDC law no.
Yeah.
Which has not been struck down to be unconstitutional.
Listen, and then the
So it's unconstitutional.
by our rules, conflict of law rules, hierarchy of norms.
Yes.
We now we enter over the constitution.
You see.
And therefore, by
but when you say me besides senior, say, is there any timeline in the constitution?
There's no timeline.
No.
No timeline.
You see, a person shall not be qualified.
Yes.
Like member of
So
parliament.
I ask, so what
So
time,
anytime
what
that
time
you
you
owe-
become a member of parliament?
Anytime that you owe allegiance, you are not qualified. Anytime that you owe allegiance
To become a member of parliament.
To become
are
a member
disqual-
of parliament,
No.
not a candidate for the election.
No, it's not to become a member.
As at
of-
December,
No,
you are just
listen,
a candidate.
look,
Yeah.
forget about this candidature thing.
Yeah.
No,
And look
how
at,
can I forget?
Look at the law, the constitution. It says a person,
A person.
and you are unqualified.
Yes.
So if you are unqualified, the issue of you becoming is even distant. You are unqualified.
Obi,
So you don't even start.
Obi.
You understand?
Obi.
Because it's those people
Who qualify,
who can start.
who can become. But now my
And
question.
therefore,
yes.
you cannot become. So it's foreclosed for you.
Obi, one will say.
You don't even go near it.
One will say,
But
Messinia,
everything- numbers are
before
who you question we are
Messinia besides raises some issue. For instance, on the issue of organization, okay, I say you cannot say I apply and that ends it.
Yes.
When I apply and I give you my passport and everything, what else is there?
Who applied today?
No, I applied. So
Okay,
like
who
in the
applied
case,
for
Hold on.
renunciation?
in the case of
Yes,
Jechi
yes,
Kwesi,
passport
eh?
to me, oh.
In
Doesn't
the-
mean say
hold on.
I
In the
don't
case,
own it.
hold on.
Yes.
In the case of Jechi Kwesi,
Yes.
I apply. I attach my passport to it.
My Canadian passport.
Yes, and then I give it to
Monye.
you. I'm not even in Canada. I'm in Ghana. I give it to a lawyer. Do the process for me with my Canadian passport. How am I still a citizen?
Yeah, but he makes the point. Say at that point, no, say Canadians, your majesty, are more listed all their citizens. At that point,
No, but
you are a
I've given
citizen.
I've given you their
What
passports.
do you listen? What's with their mouth?
I'm
lawyer?
giving you
What
your
do you-
passports.
Let me use
which
your own
you
words.
claim say identifies me. That I am
You see,
one of
it's
you.
a symbol.
I have given it to you, attached with my application, because it's a requirement, and I'm the amount. That is what I'm saying, sir. It is only fair, Obi, that this Asenov matter, we look at the justice of it. The justice of it.
Can it be done here better than
No, in the Supreme Court, obviously.
And America. And
deal
then
with that.
we have suggested, sir,
Ekosiisen
with the greatest
on
respect
Asempa
and deference
FM.
to the Supreme Court, because of how fluid this conversation is, I mean the interpretation is, when you injunct the man down, right, as the court has done, in the words of Nana Megache, his lordship,
Yeah.
it has the effect of prejudging the outcome. Because, no, please.
Of the
yes,
substantive
The
matter.
substantive matter.
No. That
Wait,
is not
sure.
correct.
Yeah, no, and this
Interim
is
injunction.
Senior, don't worry.
Does not
The
operate.
reason
Yeah.
Minka say it operates.
Yes.
I am saying, sir, the essence of an interim injunction is to maintain the status,
The status quo.
Yes.
So at this point, what was the status quo?
That the man is MP.
He was performing his duties. As at the time the
So
Supreme
you
Court
are in a
gave
land court. Somebody is building.
As at the time the Supreme Court
status quo is
gave,
that somebody is building.
as
So
at
you
the
let
time the
him
Supreme
continue to
Court
build.
gave his ruling in
Yes.
respect of the injunction,
Yes.
he was performing that.
Yeah,
duty.
but as at that same time, no, the
He
High
was
Court
doing an
ruling
illegality.
was subsisting. It was
Yes.
still there.
It was
So
an
the High Court
illegality.
judgment,
You want me to go on that? As at 27th March.
How can we say that the
Hold on,
illegality
Senior,
is
Senior,
a status quo?
As at 27th March, right?
Yes.
Lawyers for Jechi Kwesi,
Ekosiisen on
one,
Asempa
they
FM.
applied to the Cape Coast Court of Appeal. One, to relist the
Okay.
appeal. Two, almost filing for stay of execution and stay of proceeding. 27th
27th March.
March.
then
The injunction was determined yesterday.
But
And are you saying the Supreme Court never took notice
Exactly.
of what has happened at
Exactly.
the Court of Appeal?
Exactly.
let's-
Look, these
let's
are
put
the,
the facts
you
clear
see,
before.
senior, a lot of injustice have been done with the greatest respect. A lot of
no,
injustice
but
has
let me
been.
correct you.
I am
with the-
saying that.
with the application
No, senior.
to the Court of Appeal. When
No,
you-
we are
you-
talking about the High Court
no, you are
judgment. The
saying
only
that-
thing that can hold on the High Court judgment
yeah, Court
is
of
what
Appeal.
is happening at the Court
I
of
agree,
Appeal.
I
So
agree.
there was a motion to release the application that was struck down for non-compliance. That motion was filed on 27th March.
The registrar of the court
It's
can attest
there.
to that.
It's there. The records. I have the motion. And now, because
Stay,
of the
so-
consequence, a stay was equally filed
All on the 27th of
on
March.
the 27th.
Listen, we are all practitioners.
Obi.
When you are out of time
Yes.
and you are given a leave to prove why you are out of time.
Yes.
CI 19, you have, it is mandatory on the court that when you don't file your address
We have gone past
at the,
that. That
at
was
the
why it
time
was struck
given.
out.
And when your time
it was
almost
strike
striking
out.
out for
But
non-compliance.
subsequent-
Listen,
that.
before it was struck out, the council was given the opportunity to indicate to the court why leave must be given to you to continue out of time.
Yeah.
And council gave a reason, and that reason was deemed. That reason was refused.
Yes.
Meaning that they couldn't tender any good reason why they should be allowed to operate out out
Yes. That was at
So-
the time Court of
On the
Appeal.
face
No?
of motion
So
paper,
an application to release like this
Oshide,
is only a waste of
stay
everybody's
of-
time.
Yeah, where motion on notice for stay of execution under the inherent jurisdiction of this court and Rule 20 of the Supreme Court.
And
release.
look at when it was filed.
Where I think I saw
See-
Mehu 29th March 2022. 29th
What was
March.
yesterday's date?
Now NRA 13th April 2022.
So how
No, but maybe and then maybe say inti when the parties were before the Supreme Court. Supreme Court ready
So
said
that
or
is-
didn't ruling no. Did any of the councils
that,
rise
no,
up?
so that is where I am coming in. Okaya. The last day now, court no give you the ruling on the review.
Yes.
Okay, say Mr. Chikata raised an issue with the service.
Yes.
And then there was a 6-1 ruling.
Ruling.
So he went on review. That day, when he said, I have a preliminary legal objection. And now, Okaya, only my lady Agnedoji Kranya, Bantabi,
Yes.
to draw the attention of the court to all these matters that are pending at the Court of Appeal.
Matters as a genius to the court.
No,
The court
you see, what
I mean,
you are not adverting your mind to is that, you see, when this matter originated, like I told you, the lawyers for Jechikwesin, I can say, because of the interpretative matter, no, let the courts below stay and refer the interpretative matter to the Supreme Court.
It flows from High Court.
Na abekoho.
So
And now, once that, hold on, no, while that matter was pending, no, the same petitioner now was opposite the referral to the Supreme Court. No, now issues a writ at the Supreme Court asking for interpretation.
Which he's allowed to do. Anyway.
I'm not
It's right.
disputing.
Okay.
What I'm saying is, if you have said Zenato has settled the matter.
I did not say that.
No, I'm not
No,
saying
or
you.
counsel
I'm not
for-
saying you. If you are suggested, say Zenato has settled the matter, for which the High Court judge agreed and proceeded to give the judgment in the form he did.
Yes.
What will be the basis to issue the writ? If you believe in the judgment that you had obtained
From
at
the
the
High
High
Court,
Court,
now.
which the judge said there was no issue of interpretation, what would be the basis for you to now go and issue a writ at the
Maybe
Supreme
a
Court?
part of
but-
our
but
strategy.
What
You can't-
strategy? Obi, what
Do
strategy?
you control his strategy?
No, I'm not saying that do I control. But
Yes.
Obi, you see, when we say in one of the one of the Supreme Court judges, Nana Megache, and I just want to read something briefly.
We're in NRA ruling.
Annual ruling, you know, my Lord Justice Amegache, or say, effectively, you know, they are not plaintiff and now plaintiff
Yes.
applicant,
Yes.
and they
Yes.
say, to enforce the judgment of the High
Of the
Court.
High Court.
disguised
as a writ.
Is it
by
not
way
admissible?
of what is admissible? Senior,
You
look,
are
senior,
filing
me
the
know
process.
ye case. Senior, me know ye case. Now can't tell me. I will court below. Say, ye referral, na me oppose. Ya court of appeal, ye referral, na me oppose.
Can you not change your mind?
Now quickly. Who the same person now who oppose no? Who is sure? The first thing I will see now can say I'm abusing the court process.
Yes, so file that
objection.
No, that objection was taken.
File that
That the
objection.
process was frivolous,
Chachu
was
there.
forum shopping, was abuse of the court process.
And what was the result of
No,
that
they disagreed
application?
with that application.
And Obi,
Who disagreed with that?
The court disagreed with.
he said,
it's proposed.
or say, Obi, I just way that senior can take it up from there. Or say, in my view, if the applicant will not trigger the necessary legal processes available to him in the rules to enforce the orders of the High Court made against the first respondent, the Supreme Court is not the forum to employ legal ingenuity by filing by the filing of the constitutional action.
Because that extends.
And now listen, and then disguise this application as an offshoot of the writ, whilst in substance an enforcement of High Court orders, which is not an appeal before us.
Good.
I'm a got a dissenting opinion. But let me time
let me comment on that one.
Chachuka so ma file new processes for Court of Appeal no. Court ne card Supreme Court card
Frivolous.
Yes.
How could they have said frivolous?
Okay.
Okay, let me respond to that one.
Frivolous?
One of the Supreme Court judges, Justice
Amegacha,
is saying, it's all about execution. And
of High Court orders.
As we know it, execution comes after having filed.
After having obtained a judgment.
After having obtained a judgment, you file entry of judgment, and then you start the execution process. Good. But he says that he has been ingenious in invoking the jurisdiction of the Supreme Court in an attempt to enforce
a High Court
judgment. So
Senior,
now,
practice,
wait a minute. So now it becomes a matter that the Supreme Court must pronounce on and say that because you are using an unorthodox means of enforcing a judgment of a lower court, we cannot hear you.
We cannot hear you.
But the Supreme Court didn't say that. And Justice Amegache, in his personal opinion, legal opinion, even stated that you are being ingenious.
Yes.
For me, sometimes I admire people who are courageous because that is how we expand the frontiers of law.
I get you.
And now that the Supreme Court has taken this application, it opens the door for us. When you are distressed, and when you
for some reason we are coming to reduce the Supreme Court to a trial.
Listen. For some reason, listen. For some reason, if you cannot, or if you decide to invoke the Supreme Court jurisdiction, it is possible under this rule.
Under this rule, of course.
So has it not added to the law? Practice?
It has not.
It has.
It has not.
Because
but there are some few questions for clarity. Also, me busa mumi no nyina ba ansa na no. Ma me mfa we entwem na tie for ente se Bell Chill and Win promo no cost den. More among the messages here, but I'll read all your messages for you. But Bell Chill and Win promo no cost Bell beverages say more product bebre ibini tamarinda Bell Cola Ekosiisen Big Boss Squeeze Breeze Bell Malt and more. Now the almost sales say if you want to win as part of this promotion Otoya in bottles ni bia no wa white label no. Utimi white 20 labels fashion envelope mu show within or contact egu echre drop or Bell Beverages depot bia na accredited distributor bia across Ghana. Customers are more the highest entry, you automatically win fantastic prizes in the Bell Chill and Win monthly rewards announced on TV, radio, and social media. And there was a way answer with the entries in a money also, meaning say per 20 labels bebree never share envelope be 20 labels odi shemo and now the akoto box name once our entries endorse no you are winning automatically and you my channel doors home furniture set appliances hampers of Bell product shopping vouchers and the grand prize of a Kia Picanto. It's amazing what Bell Beverages year to make this year more exciting just for you. Kai set terms and conditions apply. Opesa onu wounding koma 0544 335 800 0544 335 800. Bell Beverages also refreshing the nation. Power betting, so some countries, you just join them today on www.10bet, 10bet.com.gh, and you enjoy secured betting experience, 24/7 support always at your disposal. Your instant payment, global sporting event, more than 60 different markets, virtual sport, and amazing great bonuses. In the www.10bet.com.gh. And a CBG say and fan to my name say paying your taxes no is an obligation to the state, and CBG is making payments convenient, easier, and enjoyable and stress-free as well. And you can make both electronic and cash payment for MDAs, MMDAs on CBG's platform in a very simple way. 1. Pay remotely on *222# in the *222# on internet banking and in person in any CBG branch. And in-branch collection platforms, and so customers can make payments on behalf of MMDAs across the country. And to make your payments through CBG the best platform for all payment and transfers, both electronic and cash, for MDAs and MMDAs. In the South Utria Sikebiama ministries, department agencies, and now say Metropolitan Municipal District Assembly Sikebia say rent tax, a year your friend is saying property tax. Now also Utria BB also Utriama MDA, and I say MMDA Biano CBG Okwa Ubitmetria through CBG. It is really, really stress-free. Shannon so my website cbg.com.gh. For more details, and Zubit Mafrain 0302 216 000 CBG. Or see, we stand with you. Unim say under the distinguished auspices of His Royal Majesty Dasibre Ekwuamwa Ejapon II and Her Royal Majesty Nana Adjoa Jemfua III, the Ghana State Book, Dasibre Development Advisory Board, and Kwewu Traditional Council, and Kwewu Golden members, they want to invite the general public and all of Kwewuman to the Grand Deba of the Ukwewuman to launch the Kwewu State Book. Where a Grand Deba here to launch what we call the Kwewu State Book. So in the April 16th, 2022, our Empraeso Social Center, 9 a.m. pepepe. In the Wood na East Ekosiisen on mark this on your diary. Now make sure say you will be there. Saturday, April 16th, our Empraeso Social Center. Here launch the Kwewu State Book. In the Kwewu phone across the country. And was some mama yin na yeko boa na bibia ye kama. Easter yin so beton your man kwa dia Malcolm say we want to put smiles on your faces and that of your family and friends. Momra na mo shop for mo goods at very affordable prices. Our Malcolm branch bia T's and C's apply. Malcolm is where Ghana truly saves. In the Okowa, Nyoma ne boy for party a Malcolm and a ubenya etimi ato. We are a young entrepreneur now into manufacturing, information and communications technology, agro processing, energy production, waste processing, tourism and creative art, or horticulture and medicinal plant. Me pacho. GRA say, or tax exemption for the first 5 years. I will pretty. Or first 5 year amount tax exemption. Once you're a young entrepreneur and you operate in any of the industries, first 5 years, tax exempt. Untria tax. It's amazing. And after our first 5 years, or next 5 years, your tax rate be very, very low applicable to you. In the Accra and Tema, over 15% per. Other regional capitals outside the 3 northern regions, 12.5%. Outside other regional capitals, 10%. The 3 northern regions are 5%. Opesa wo timu nsem ya oni GR ni nkomo. Omo office bia wo di wrem na koko busemu ye. Ghana Revenue Authority, integrity, fairness and service. Answer na mekwa kwakotie we aba no. Eduji na mpese me busa this question.
Yes,
And on Electoral Commission, omo receive petition from the concerned Asin youth. Omo to suffer education say omra. Yenim say isi nye quasi judicial body. Omo administrative body.
Fantastic.
Were they clothed with the power to vet renunciation certificate this animal and say okay, you pre-qualify kwane kojina?
Yes.
No more sa power no.
Yes, because in the decision, that is the Republic versus High Court,
Yes.
as party Electoral Commission, Dr. Parkway Indum interested party.
Yes.
Supreme Court, speaking through her ladyship, Sofa Adinra, took the view, say, the Electoral Commission has the power to even permit
Ekosiisen on Asempa
amendments
FM.
to even be done on your nomination
On
paper.
your nomination paper.
And that is why the court said, Oshia, Omoma amnesty, general amnesty to all the presidential candidates.
Yes.
By reason of Madame Charlotte said then, the Electoral Commission disqualification, they were all permitted to go through. Ebin Wokaya, Omo Nkrofa, Omo second year, Omo propose, Omo were persons with dubious validity or something.
Yeah.
That was the allegation. Eventually, they were all given the opportunity to do that. Because matters bordering on election, per our constitutional arrangement, are reserved for the Electoral Commission. In fact, it is only when the Electoral Commission is engaged in an
You are
unconstitutional
talking
conduct.
about allegations unproven.
Unproven.
Allegations. We say there were a lot of allegations.
No, easy they make allegations in disqualifying the
Disqualifying those people.
And those allegations were not proven.
in a court of law.
Yes.
No, they were proven.
Say a court.
Echo court.
And the allegations were proven to be right.
Even though the allegations were proven, the court took the view that they ought to have been heard. Okay.
Absolutely.
Yes, so
They ought to have
therefore
been heard.
they were not proven.
No, how?
If you don't give
So-
hearing
hold
to
on,
No,
hold
the
on.
decision was on the rule of natural justice.
Yes.
It was not
Say,
the substantive
and yet the substantive
allegation.
yes, but
But
if you make an allegation
I'm even
and you
making
cannot
is,
you
based on
cannot
the way
sustain
now
it
we raise it,
upon
the Electoral
natural
Commission has
justice,
it.
it is not proven.
Because
But Edu Jimmy Pacho, the Electoral Commission mandate say matters about election ni bibia ewo in their bosom no.
Within the law.
Yes, within the law.
Yes.
Does that include a judgment call on whether candidate A or B go through the process of renunciation of citizenship or allegiance to another country? Can the EC make that determination?
yes, they can.
Why?
Are you sure?
So why do they accept even who?
If they can, what
Assuming
has happened?
Assuming a person like presidential,
Yes.
and I remember the last time H. John Dramani Mahama
Yes.
said we have to put everything together.
Yes.
You go for 2 persons from each constituency as the persons endorsing.
Yes.
If it turn out say one of the persons who endorse, and you have to endorse with your voters card, only indeed 18. But okra voters card, endorse here. What would the EC say?
When it is proven,
No,
say
only
it's in
18.
breach of
Only
the law.
18.
Yes.
When it is proven,
Ekosiisen
But
on
when you have
is
voters
Asempa
card,
FM.
Okay,
if
the
they are
presumption is illegal.
Aha!
Yeah.
So in that case, the EC has the power to even say that based. And remember, say, even in the Hindu matter, the court said if the Electoral Commission had
Asempa
given the people
FM.
the opportunity, that's hearing, and having done that, proceeded to disqualify them, that would be perfectly within their remit.
so it means that
But to the extent that
allegations
that was
were
not
unproven.
done, but they proceeded to say they were deemed disqualified without giving them a hearing.
The hearing.
Then
That
the
is
rule
the
of
rule
natural
of
justice,
natural
because
justice.
administrative bodies ought to comply with
Yes.
those rules.
With those rules.
And therefore they couldn't prove the allegation.
No.
Yes.
No. You see,
Oh, come
judicial
on.
review is not a merit review. You and I know
No,
that.
no. Listen.
When an
They are
administrative
saying-
body takes a decision,
Yes.
a judicial review does not do a merit review
Of the substantive,
of the substantive
way,
matter.
yeah.
What you
It is-
do
what
is
you
to
do
find
is
out
set
whether
aside.
there are procedural impropriety.
Yes.
Impropriety.
But
Whether
procedure
people-
and the law substantive, they make
No,
the
no,
law.
no, sit down, sit down.
Who said
So listen, natural justice principle is the primary law in the whole world.
But it's equally a procedural rule.
So, if you don't comply with natural justice expectations, whatever you do is void.
Ekosiisen on
And it will be
But it
denounced.
doesn't mean that
no,
it's
yeah.
a merit review.
It doesn't
No,
go
it mean-
into the allegation, the veracity
But
or otherwise.
if the
of
thing
the
is void,
allegation.
what does it mean?
Oh, no, senior, please.
If it is void, it means it doesn't exist.
No, but it's a different thing. You see,
No.
and that is why if you what kind of judgment of His Lordship Justice Cheba for who
Yeah.
decided that
Yeah,
matter,
yeah.
he took the view that look, if the Electoral Commission had given the people the opportunity
They
to
did
speak,
not.
hold on, no, had given the people the opportunity to talk, the people did, and after all this, the East still said, look, you see this your document. You ought not to have attached it, but you've done that.
Yeah.
So on this basis, having heard you, I am
I still
disqualifying
disqualifying you.
The court said we cannot now make an incursion into it.
Into it.
But since you did not offer them the opportunity,
to be heard.
I remember it was my senior
you
equal
see,
to who
sins
argued
against- yeah.
that matter.
You see,
It's
and
sins
again,
against-
It seems against the rules of natural. So
you
it
see,
was not a merit review.
No, natural justice principle is supreme. If you don't give a hearing,
Yeah.
whatever you do can be voided because you didn't do it. And if the evidence that you rely on,
Yeah.
you make an allegations and you rely on evidence and you say that I didn't give a hearing to the party, how can
Ekosiisen
that
on
be conclusive?
Asempa FM.
No, but it doesn't
Okay.
mean that
In-
the
in therefore,
allegation
in- I
stands
think-
unproven.
It's unproven.
No.
No.
Wait here. I think we have to do the last leg, which is now that the Supreme Court the Enra ruling no abba. Ruling is the Honorable Judge Ekosiisen entimin kase or MPBO. He is injuncted
No.
pending the determination of the substantive matter. Does that present a leeway for the EC to go ahead and organize a by-election in the constituency, as some are arguing? And that will be the final leg in this conversation. My main kind message is kakra nafe yemra and also we say Obi is lawyer Eduji telling us that after filing forms to join the military, I could just move to Burma camp, start wearing the military uniforms because I have submitted my forms. Again, if I've applied for visa, I could just go ahead and purchase a ticket on the premise of having submitted my application. This doesn't make sense no matter how we spin it. It is difficult to defend the indefensible. Samuel, Brian, Boabin, and Odiwe. We say, Obi, believe you me,
Ekosiisen
what
on
lawyer
Asempa
Eduji is
FM.
saying is an afterthought. The NDC never raised the issue of constitutional interpretation before the High Court to warrant the invocation of the stay of proceedings embedded in Article 132. It came much later. In any case, the Supreme Court held in ex parte accosa that the High Court judge is not always bound to refer every matter to the Supreme Court for interpretation simply because a party has raised it. If the judge thinks the provision is so clear, no, Tobo. Or see, if the judge thinks the provision is so clear, he is entitled to proceed without referral. Secondly, Article 129 thereabout of the Constitution allows the Supreme Court, in hearing a matter properly put before it, to assume all the powers, including enforcement powers, of the courts below. So the Supreme Court did not err at all, even if what it did was to enforce the ruling of the High Court. Idi Mohayuddin and Odiwe Abraham. This one says, Hi Obi, I'm not a lawyer, yet the issues are clear. Yeah, it is at the law school. No, Idi Mohayuddin your law school, Ghana of law now. And the Esson sa Idi no.
Ekosiisen on Asempa
Where
FM.
Idi Mohayuddin, who is aide to the General Secretary of the NPP. Idi Mohayuddin.
But there's another AD
Okay.
who is
Okay.
qualified, indeed my senior.
Oh, your senior. Okay. Well, so while 24.2a does not speak to what allegiance means, Zaneto is clear that election is a process that begins at the filing of nomination forms. Atuguba JSC settled the matter. By the time you file your nominations, all your requisite document must be ready. Everything must be While it is unfortunate Ekosiisen brought this upon himself, the NDC did not go to the Supreme Court for interpretation because they knew that Ekosiisen's case sins contemptibly against the Constitution. They were fully aware of it. If you read Kolendi JSC's reasoning of the majority decision, you realize the poverty of the approach the NDC employed, even with the venerable Chachuche Kata leading the case. Kudos to A.G. Dame and Frank Davis for securing this outcome. It is a landmark case for
Ekosiisen on
Ghana.
Asempa FM.
We Efri Kojo Frimpong and on the way Abba. We say, Obi, if voters registration exercise is to end on the 5th of November 2020, and I will be 18 on the 10th of November 2020, knowing this, and I register on the 5th of November 2020, and I'm taken to court on the 15th, when I have now attained 18, Obi, do I fall foul of the law, or I should be left to go free? Paul, half as me. With the scenario, you still fall foul of the law. And the same thing happened in this case. Okay, that's an interesting perspective. Where's Obi, please, let us help the education. Is allegiance same as citizenship? I know some Ghanaians who are in the US of A or UK army, but they owe allegiance to those countries by virtue of their occupation, but still hold valid Ghanaian citizenships. Eugene Elliott, a constituency secretary for the NDC, Clotte Corley, and anyway, Abba. But I'm also raising another interesting point, Honorable.
Allegiance that progresses into citizenship.
So it's not the same.
Yeah, it's not the same.
But if you like, the citizenship is even greater than the allegiance.
Putting it on pedestal.
No. If you look at if you look at it in set language,
yes,
citizenship is a superior set, and allegiance is a subset. So once you reach citizenship, you have already committed yourself in allegiance.
Yeah, of course. Back when you send Kwanon to the other. Yeah, I get you. Enti, Mama Yentia Wemra, yaba 2 lawyers here. We'll look at the issue of a by-election. Is it feasible now with ruling Enra